morning to everyone, all the magistrates out here. It's good to see all of you together. No one is online and listening to that. So we all have done this NIACT cases. Most those who have presided over courts in Gangtok, especially Judicial Magistrate courts, they have done a lot of NIACT, including Chief Judicial Magistrate Court. So other jurisdictions I do not know is Mr. Jasen. How many?
So I have decided 2 cases and there are 8 or 9 pending cases.
One has been decided, sir, recently. As of now, there's 2 or 3.
And Japan?
So, all my cases has been settled so far, but right now...
You had cases, right?
There are 2 judgments in my now.
Okay. Rohini?
I'm not too sure, sir. I think must be about
50. Everything?
So not at Rampo, but at Jortang, I have lot of NIAs. It's 12, 13 NIAs.
Okay. So it's actually, if you see, there are Supreme Court judgments also, which I've observed, and in my personal view also, it makes this NIACT under 138 makes some kind of a act of civil nature into a criminal offence. So one need not be very serious about this law, in my experience, especially when it comes to punishment. The main objective of the act being that the person who is lawfully entitled to a certain amount of money that is made in the check, that's his main purpose. And even if you see the complainant, they are more interested in getting their money back rather than sending someone to jail. So when it comes to punishment, the very rare in sending someone to jail in these cases. It's not required. One thing I like to present before you all is that at one point of time, check was the very much prevalent mode of transaction of high value amounts, which is not much now as compared to I think about 10 years back maybe check was very prevalent. Even in initial stages when we joined our service, check was the most prevalent used method of transferring money. If someone asks you money or you're giving to someone in a quite big amount. But nowadays we have various forms of transactions like online mobile banking to IMPS. We usually transfer funds even from our accounts to another, or if you are transferring it to your family or friends, someone like that. So the check has so far, in one sense, when it comes to transaction by ordinary people, its method, its prevalence has reduced. But when we go to big business firms, companies, check is still the prevalent mode of transaction when it comes to finances. So the method of transferring money through check is still prevalent and the law is still relevant in this context. So, we have 2 major provisions in the NIACT which relates to territorial jurisdiction and cognizance of offences. I'll speak much less because I'll most probably pointing out to Ms. Rohini, who has fortunately by virtue of being posted at Gangtok has dealt with a lot of NIACT cases. So we'll be looking answers from you. Of course, it's open to all other magistrates also. So tell us something about who is the oldest. I think, let's begin with Naividya. In territorial jurisdiction at one point of time there was a lot of confusion because of one judgment called Tasrat Rup Singh Rathod. What was that? Can you tell us? Anyone, it's open to anyone. It was, I think, somewhere around 2015-16 this judgment came, and all the cases had to be transferred from one jurisdiction to another. And what was the solution to it? Anyone? Okay, ma'am.
I think
You can switch on.
judgment.
You all are resource persons today.
The territorial jurisdiction was, as per the judgment, lied on the court, in which under whose jurisdiction the bank account of the complainant or the drawer of the police
Yeah, actual bank branch we talked about.
where it was located. So all the cases where previously the complaints were lodged in the courts, where the checks were deposited, they were transferred back to the
Yes, absolutely correct.
court.
That caused a lot of hardship because, you know, I could present my check anywhere as long as that bank or its branch has my account. If I have an account in SBI, Jordan, I can present my check at the end of it. So, you know, that conferred territorial jurisdiction initially. But the judgment said, no, where your account lies, you have to file there. So, you know, what happened was big business firms, they were depositing checks anywhere because, you know, in any of the branches. And when this judgment came, they had to particularly go to that branch where their account existed. So that created a lot of hardship. Now that still remains, that law is there, you can file case there also. But where you have deposited your check, or in the bank, which may not be a branch, that also has the territorial jurisdiction now. So you can file anywhere between these two jurisdictions. So then immediately after that judgment, the government had to take out an ordinance. The parliament was not in session, so they had to take out the ordinance from the President of the India and, you know, bring out the law, you know, relegating the hardship caused by that judgment to the complainants. We may read this jurisdiction part. More difficult than POCSO when it comes to accused. Okay, the reverse burden is such a thing in this act. You may get acquitted in POCSO, but very rarely in an act, because of the presumption it holds that when a check is drawn, it is presumed that there was a debt or liability. So acquittals in enacts are very rare. So let's see the territorial jurisdiction first. What does it say now? And one more thing you may ponder upon. There are two words used in this section. One is you know, the drawee, and the other is holder in due course. We rarely have done cases relating to holder in due course. So what it could be? We have almost all the times, I have not done any single case which was produced by holder in due course, but it was produced by the drawees. That situation might come, you know. Where any check drawn by a person. Now, one of the most important thing that you must know is any check. Okay, it has its relevancy, which we'll discuss about later on when it says any check. When any check drawn by a person on an account maintained by him with a banker, it does not say branch, okay, with a banker for payment of any amount of money to another person from out of that account for the discharge. And this is also very important. One of the ingredients of offense is also discharge of debt or liability. In whole or in part, it could be half, it could be whole. Of any debt or other liability. Now these are two distinguishing things. You know, debt is one thing, liability is something other. Its relevance we'll talk about in a few moments. Is returned by the bank unpaid. It should be unpaid. Either because of the amount of money standing to the credit of that account is insufficient to honor the check, or that it exceeds the amount arranged to be paid from that account by an agreement made with that bank. Such persons shall be deemed to have committed an offense and shall, so and so forth. If we see section thereafter, 142. The purpose of cognizance, you do not look at CRPC when it comes to an act. This itself has its procedural provision for taking cognizance. For section 38, there is also a proviso which says that the check has been presented to the bank within a period of 6 months from the date on which it was drawn, or within the period of its validity, whichever is earlier. Is 6 months still valid in law?
3 months.
Yes, now they have changed it to 3 months. that 6 months is just a word, no longer operates in that manner. Now all the checks issued are only valid for 3 months. So the check must be presented within its validity period, that is 3 months, to the bank. If you present it thereafter, the bank will obviously dishonor the check, but that will not be a ground for initiating proceedings under an act for criminal offence. The payee or the holder in due course of the check. Now I want to know who can distinguish between payee and holder in due course. These are two distinct things. We are not much aware of holder in due course because I think none of us have done this case when it's holder in due course.
The payee is the person whose name the check is
Yes.
on, and that he can actually mark the check to someone else.
Yes.
Who can use the holder in due course.
Yes, absolutely correct. A check can travel. Even that person can give it to someone else, and the other one becomes the holder in due course. There can be many holders in due course. Now, what happens when such check bounces? Is he entitled to, claim, and from whom then? From whom, Mr. Chandra? Against whom will he claim?
Against the drawer.
Yes. Against the drawer or even the person who has endorsed. He has a right to claim against all or any of these persons, but drawer has to be there because it is his account which is maintained, from which the check has bounced. Okay, so the holder in due course can be a person to whom the check was endorsed by the payee. And when it comes to holder in due course, there must be a consideration. Okay, the check must have acted as a consideration, otherwise he has no role to play. And he has one more right that if the drawer was not entitled to draw the check, or the holder or the payee was not entitled, there was a defect in the check as to the title of the check, okay, still that will not be a defense for the complainant to say against the holder in due course that she had no authority to give the check, therefore I gave it to you. Whereas that may be a defense, depends on the facts of the case, when it is a payee who is claiming against the drawer. So holder in due course has certain more rights than the payee when it comes to claiming the amount. Particularly being that the defect in title cannot be a ground of defense for the accused when it is claimed by the holder in due course. So first thing, when a check comes to you, examine it whether it's directly claimed by the payee or the holder in due course. People may not be knowing it that they are holder in due course, may claim themselves to be a payee and may write so in the complaint. So cognizance, very first thing you do is mathematics. You sit down first when the complaint comes, you start calculating whether within 30 days the check has been deposited. If that answer to that is yes, then you move on to the next clause, which says the payee or the holder in due course of the check, as the case may be, makes a demand for the payment of the said amount. So making of demand is very, very essential. It's one of the ingredients of offense, by giving a notice in writing, okay, to the drawer of the check within 30 days. I hope it's still 30, because I've been out of this for quite a long time. Within 30 days of the receipt of information by him from the bank regarding the return of the check as unpaid. How do you get information from the bank that the check has bounced?
There's a slip that is issued saying that fund insufficient.
Or any other ground. Usually, they do not have usually the other columns. Or most of the banks, they are writing insufficient fund, even if it's some other reason, because now law has grown and there could be many reasons why you can initiate the proceedings under an act, not just insufficient funds or exceeding
Dormant
arrangement.
period for dormant sum also.
Pardon?
Dormant is the word that is used by the banks. Saying that account is not being used.
Okay.
On that ground.
On that ground also we can sue, no problem. Because the main intent of the act was, they did not foresee at that time that there could be so many reasons for the check getting bounced. The most prevalent could be when the legislation was drafted that exceeding arrangement. At certain times you have an arrangement with the bank that if someone claims a check above certain amount, please don't honor it. So when that happens, that check gets bound. That's an agreement between the customer and the bank. Okay, that's for one's own protection, that someone may find the check and with your signature and put an amount and so it's a kind of security thing. Because you get information, because you are interested in that money, right? When you go to bank, they may not initially transfer it to your account, it might take time. So when you visit your branch, or nowadays I think you also get SMS that the check has bounced. The moment I, as a drawee, get that information, within 30 days, it's not 1 month, okay, 30 days, don't confuse, 1 month may have 31 days also. Within 30 days, you have to give a notice to the complainant that you owe the debt or liability. Those are the facts usually mentioned in the notice of so and so amount. You gave me this check dated so and so, I deposited it and it got bounced. I call upon you to pay the due amount to me, okay? After that, what happens then? The drawer of such check fails to make the payment of the said amount of money to the payee, or as the case may be to the holder in due course of the check, within 15 days of the receipt of notice. The most litigated portion is this, the notice, whether it was received or not, right? So within 15 days of getting notice, I have to pay the amount to the person claiming it, that's the drawee or the holder in due course. If I do not do so, his right to file a case against me begins. And if I am paid, the issue is solved. So it's a very much of a civil nature, but the offence has been made under the NI Act with certain objectives. That's why the punishment is also not much. So anything on territorial jurisdiction and cognizance, both are clearly written words in the law. It's not confusing at all. And next comes condonation of delay. What's the provision? Can you condone the delay?
It can be condoned. Sufficient reason.
Okay, what can be condoned? Which period? Period of notice or what?
Period of filing the complaint.
Yes. Have you ever done anyone condone? Yes, ma'am. Tell us something about that case. Put that, switch it on.
I forgot the facts of the case. It was a case when I was posted in Jodha. I cannot remember. I think it was due to what was the reason? I forgot. But I had condoned the delay.
So behind condonation of delay, and yes, Mahima, condonation of delay. When do we condone delay? It's not only in this law; it's a general law also. For any sufficient cause, when it is said.
So when it is clear that the person did not seek after his rights, what some part maybe on his counsel or something that was beyond his control.
Beyond that, is equal to act.
Sir,
Who said something?
Every
Sir,
day.
It's open to the others also, okay? Those who are still in.
Sir, if there is a delay in filing a complaint, and if a complaint has been filed beyond the prescribed period, then here the complainant has to satisfy the reasons for which the delay has been caused. And if the complainant is successful in satisfying the court that there were sufficient reasons for doing so, then here the court will take into consideration, and it is the discretion of the court whether to condone the delay or not to condone.
Okay, how strict is this? How strictly you will sit as a judge, or will you be liberal? That's my actual question. You made the legal point clear, okay? So how will you sit as, how will you exercise that discretion? That's what I'm asking.
So we have to see broadly. We need not see each and every day's delay. And I think there are like several grounds for delay. I mean, where the prescribed period can be extended under the Limitation Act.
Yes. Usually what happens practically when people come with condonation of delay under NI Act is either they have, tried to litigate in a different jurisdiction because of wrong advice of the lawyer, or lawyer himself got confused. That is one of the reasons usually. You will not find any other reasons, I was sick or all this thing. That may be a reason. But usually it is, when it comes to you for condonation of delay, the person would be litigating in some other court, and after so many months, from that even years, because in other courts outside the state, it takes years to reach from one stage to another. So the court would say, I do not have the territorial jurisdiction, though there is a process for what you should do when you do not have a territorial jurisdiction on an act. We'll go to those judgments later on.
So,
So those are, it should be condoned actually.
sir, I have had cases where there is an intention to pay. Like if the amount is about say 10 lakhs, like the Bapani 50,000 or like there is kind of a correspondence between the parties and there is a little bit of an intention to pay.
Okay, they come for only part of claiming it. Yes,
So
I think
those
that is
cases
a
I have-
wrong to, because when you are condoning, the person intended to pay, let's say out of 10 lakhs he could pay 5 lakhs, so 30 days after notice are gone and all, But I think if the person is still not paying it, then in my view, depending on the facts of each particular case, that can be a sufficient reason to condone the delay. Obviously, it should not take, a person should not sit over the case saying that if for 2 years and all saying that I am paying it. That period also I think that should be seen, but of course it depends on the facts of each case. So yes, it can be condoned, and we need not be very strict. Even the strictness that is there in the Limitation Act, the judgments, the condonation of delay judgments, you mostly find in relation to the Limitation Act. That is also very liberal, but some of the judgments therein are very strict, okay? But for NI Act, looking into the purpose, the context in which it is made, of course your description should not be absolutely without any reason also. There must be some reason why you are condoning. Usually it will not be interfered by the appellate courts, okay? So these two are pretty clear, right? Anything from the ones who are still in training? I don't remember him. Sorry. What's your name? Okay, Devkumar. I have to know in territorial jurisdiction and cognizance and condonation of delay. Tell us something. What you understood? Whatever you understood. You have not done cases. It may be difficult.
So with regard to territorial jurisdiction, what I understood is it can be filed in two places. One is where the bank is located, and then the...
Which bank?
Sir?
Okay, Roy's Bank.
Yes, Roy's Bank. And then the other can be filed in a place where the check is deposited by the
branch.
Yes, on the person. And then with regard to limitation, if there is delay in filing of complaint before the court, then the court need to be very strict to...
Okay. One situation might come, okay. Sometimes the lawyers don't file condonation of delay, but when you go through the petition, you find it is delayed. What will you do in such a case? Yes, sir. Will you outrightly reject it?
So I think what cannot sue.
Then what can you do?
I think the party can be asked to file necessary application explaining the delay.
Yes, you can do that. That's the correct answer. Because if you reject it, the appellate court will definitely set aside the order and say give the opportunity to the person to file the... So why to go into that length? You can just call the lawyer and say, see, this is it. Most respectfully, you may have forgotten the law, but please file a condonation of delay. Obviously, you do it. There is no other option, right?
So I think in one Guwahati High Court judgment is there, which says that we cannot take cognizance of a complaint on the NIR if the delay has not been committed.
Yes, yes. So what we will do is we will not take cognizance. What
has already been taken. How can we proceed and hear?
No, what my point is, if the complaint comes before you, you read it, right? You find it is delayed. What's wrong in calling a lawyer and say there is a delay?
At that stage it can be, but after the cognizance has been taken.
Yes, after the cognizance there is no point. Someone has to go to the revisional court and do something
then
about
we'll
it.
have to reject it.
Yes, yes. Because that stage is over. Unless you have delayed the condone the delay, there is no lease out there in your court, right? So it has to be before cognizance. That's correct. So you can tell the lawyer. Otherwise, obviously the lawyer will, the other party will engage the same lawyer or a better lawyer, and they will plead in the higher court, and the higher court will say, okay, give the opportunity for them to file the condonation of delay without getting influenced by what has been said here. So that's it. I think everyone got this. The written complaint, I think we must go to the ones. Yes, Mr. Subba. What is a complaint in criminal law?
So, a complaint is an allegation made before the magistrate, informing that someone known or unknown has done something harmful against that person, like his rights has been infringed.
Okay, correct. What if there is an FIR and a charge sheet with 420 and 138 both included? There is a charge sheet, comes to a court for an offence of 420 primarily, police add anything, they write 138 also. What will you do?
We take the cognizance under 420 but not under 138.
Anyone agrees or disagrees? She said, I'll take cognizance under 420 but refuse under 138. Yes, Aishwarya ma'am.
You have to file a private complaint for 138.
But it's there before you. What will you do? That's what I'm asking. She said, I will not take cognizance of 138 but only proceed with 420.
You can direct the complaint to approach the complaint.
Because the complaint.
Yeah, if you are a very good judge. Others, I would have not said anything about this. Yes, we cannot take cognizance of 138 in the FIR because that's not a complaint. Okay, complaint has a different definition under the criminal law. It begins from 200. Okay, there is one provision. Now you have taken the cognizance. Yes, you was about to say something, ma'am.
So you told that not to take cognizance, like as ma'am has also said, under 138, but however, it can be converted into a complaint, the police being the complainant.
No, private complaint it has to be registered. Police cannot.
Because that
Okay,
is a
ma'am,
private complaint.
No, we can discuss. No, yes, fight on.
Because, so as you told that, like how do you define complaint under the criminal law? So when we go to CRPC or the new BNSS, so the definition of complaint is like if even after the investigation it is found that if it is a non-cognizable, then here it can be converted into a complaint case. But however, 138 is a private complaint, so yes, I understand.
Yeah, that's legally you are true. When there is an FIR, actually the actual process is if there is a cognizable case and a non-cog both in the charge sheet, then non-cog is treated as if it's deemed to be cognizable. You can take cognizance. But when the police charge sheet only speaks about non-cognizable offence, then actually it cannot be treated as a charge sheet. The process which we are also not doing, I do not know what happens in other jurisdictions. The actual process is when, let's say the FIR is under 326, which is a cognizable offence. The previous section, okay, I don't remember the new section. Now police finally say no, 326 is not made out, it's 323, right? The actual process, the police should be deemed to be a complainant and it should go under 200, but we are not doing that. No one is challenging also, someone can try it. I did once or twice, but it became such a hectic procedure, no one was understanding because they had no habit of going through all those things. So I left it.
I think like in respect of other offences, she is correct, but NIACT is a special act.
Yes.
138 is cleared by the payee or the holder of the person.
Police cannot.
So
take
yes,
complaint.
yes, as ma'am said, we can advise the complainant that you cannot do this. Or we can always inform, they are not, they are always ignorating the real parties. So we can always aware them that this is the law, but you cannot take cognizance of 130. You can proceed it with 420. But the evidences that may be relating, that may come in 138 can always be considered. Just because I did not take the cognizance of the offence, I will not allow any evidence in that context is wrong. Okay. The checks can be exhibited, whatever can be done. So now the next is, what comes next stage? You have taken the cognizance. Do we need to examine the complainant?
Yes.
Okay. Okay, you may be correct. Anyone who doesn't know or would say something else than what the both said? What both said?
You will have to examine the complainant if the accused is from outside of the jurisdiction. You'll have to, in fact, conduct an inquiry.
No, that inquiry is before issuing process, right? No, I'm not on that. Examination of complainant under 200.
Has been filed, then I don't think so.
So how many of you have done that? Yes, you have done.
This is
ask them to authenticate the evidence.
So let's talk on this authentication also. What's the point if you are calling someone to authenticate when the whole object of an act is to, those are judicially made laws. It's not Indian Act that you can take affidavit. Okay, on verification you can do it. So even I used to be confused, but I till the time I was a judge in the court, so the time was the way out. What's this authentication?
It's to give an advantage.
It's an affidavit.
It is an advantage given to the complainant because he may not be able to remember all the check numbers, dates. That is why I think it's an advantage.
No, but isn't the affidavit sufficient?
And I think this is NI Act is quasi-civil in nature. Because of that, 18 or 18
No, in
rules.
civil law also authentication is there.
Yes, order 18 rules.
What it says?
It says that the plaintiff can tender evidence by way of affidavit.
Yes, that's what I'm saying. Evidence comes on affidavit. Authentication, we just exhibit the document and signature. So is that a real process of law? I do not know. You all may know.
So I think authentication is also not required.
Not
If the
required.
affidavit is
So
required.
the authentication is also a form of examination also.
But one thing that comes is, when we go to the evidences are given on oath or solemn affirmation. What about this? Is affidavit a solemn affirmation? Then it's definitely
It
not.
has to be tendered on oath. The evidence of affidavit is taken by the court.
Even our
We
that
have to make the person take oath and then he'll tender the
Yes.
evidence on that.
So that's what he's saying is, if that's on oath or a solemn affirmation, whatever it is, why to authenticate he's saying? Says here. So Rohini man says no, it needs to be authenticated. So you to argue. Let's see.
The signature has to be identified. So the person has to come in the doc and say that yes, these are my signatures.
He has already sworn these are my signatures, hasn't he? He has already sworn.
He has to take
Sworn
oath,
on
he has to tender the evidence on affidavit and say that these are my signatures, these are being prepared by so and so, under my instructions, the contents are correct. That is,
Which provision? From which
there is
provision?
no such provision, but it is a practice.
It's a practice. He differs in this. He says it's not required.
So I have followed the same procedure.
Yes, even I followed.
Somewhere I read that affidavit will suffice.
Yes.
I think so. The witnesses also have to identify the document.
Because if you are already calling the complainant to authenticate, then what's the point of Supreme Court saying you can take it on affidavit? The whole purpose was to reduce the time taken, right?
Because authentication
Yes,
will not
yes.
take much, not more than 1 minute.
That's
And
your-
moreover, sir,
That's
they
your
will have-
handiwork,
so
not
they
this.
will have to identify the documents. I mean, they affidavit sometimes they will mark photocopies also as exhibits.
So how are we
So
going
we'll
to
have to
refuse
check.
that.
We'll have to
You
check.
can
That's
refuse to
what we
accept
have
the
to
photocopies.
That's why we need to
How are we going to
authenticate.
mark it as a
No, that's the way you are finding out. I'm saying, is it a requirement of law?
Then how are we going to mark it as an exhibit, the signature? Who's going to mark it as an exhibit, saying that this is exhibit C1, this is exhibit C1A? Lawyers not going to
Sometimes they will mark the
Don't they write
photocopies.
exhibit in the affidavit?
They write that.
There's a judgment
But
which
then
says you can
improper.
directly do cross-examination of the complaint. Forget about everything.
Sir, I think whole purpose
When it's filed on affidavit. Yes.
sir, I think the whole purpose of us examining the accused is because
No,
generally-
complaint.
sorry, the complainant is basically generally when the police files the complaint, the research is done, police has done the investigation. So for us to take cognizance in that FIR is because police has already done the investigation. Now for us, before taking the cognizance, a private complaint is when the person comes and authenticate, it is the inquiry that we are conducting, just inquiry in the sense that if the check is correct and everything, so that we can take the cognizance on that. Because private complaints, they can file on any.
No, understood. But this is an act, no? It has a specific grounds of taking cognizance. One is missing one. If all those exist, then you have to take cognizance.
For us,
Whereas in other laws, let's say it's 420, whatever, 363, then you look into, whether what the complainant is saying. Here if they are mentioned, I gave the check on this date, there is the check, it was bounced on this, I gave notice on this, I have no other option apart from
that
taking
is what
cognizance.
he is saying and he has presented the court. But to authenticate that check and authenticate the complaint that he has filed, he has to come before the court before we take cognizance. On what basis are we taking the cognizance? Just because he has stated,
Of course, in an act, if you see the check, the notice is there. which speaks about the date, you cannot go beyond that at the stage of cognizance. If all the notice are within time, the check bounce is there, check dishonor memo is there, then you are bound to take cognizance. How will you not take it?
So how do we know those documents are?
It's an affidavit.
So I think section 155 clear.
Though it is filed in the form of an affidavit, we cannot consider the affidavit as evidence itself. For that, because it does not fall under the definition of evidence under Section 3 of the Evidence Act. Therefore, we will have to authenticate. Because affidavit is not an evidence.
I think this dilemma has been solved by the BNSS.
Okay, ma'am.
As per the new BNSS, any private complaint, the accused also has to file a reply. They don't need to take cognizance. But as far as NI Act is concerned, the exemption.
Now, can you read that? What you're talking about?
220.
Discussing this, I have asked my patient to send the relevant judgments.
I never understood this, that's why I'm asking. I also authenticated, but deep down inside my mind, it says it's not
I
required.
think all of us are authenticating it. For the sake of
Affidavit is not an
being
evidence. It's not an evidence. Affidavit.
223.
223. But I think in Negotiable Instrument Act, we need not issue hear the accused and give him opportunity to be heard. Because there is a High Court judgment which has stand.
But now the jurisprudence is that interpretation is that 223 is not applicable to NI Act.
Yes, there are
That's the
few,
difference.
223 of what?
It's not applicable.
BNSS.
Which is shortened the time.
So what is the concise answer? What you are telling? That means what is correct? Whether we should authenticate or not?
We should.
Okay, what
We should.
What does BNSS say?
NI Act, no, not needed. Not needed. Authentication is not needed. As for the new BNSS. No, that is the interpretation of High Courts. About Supreme Court को पुग्नु न बाकी छ sir. It's like Kerala.
This is still a gray. What she said is also correct. It cannot be considered as an evidence, right? But from which provision we are flowing of authentic? Let's say in civil cases, from where we are understanding, the accused comes in the dock and says, "This is the document. Exhibit 1 is my complaint." Does that?
Accused does not have the right to file affidavit.
Sorry, the complainant. If he says that this is the document, mere one formality of saying this is the document presented by
But
me.
he will be speaking on oath. So it means something.
So no, affidavit isn't it on oath then? It's on oath.
So when we authenticate, he will be administered oath, and the affidavit which he has sworn is not an evidence.
And one more
per
thing,
se.
when he is authenticating, what he is authenticating? The contents. When you
Contents,
say, that means
contents
when you
and
use the
documents.
word authenticate, it means you are believing it to be absolutely true when it comes, when it's still not.
So, but he is on
For
oath.
that,
He is identifying at the most we can say,
So he
right?
is on oath. He is identifying on oath.
Before we come to the
So,
But otherwise you'll have to tell everything, then you'll only say this exhibit 1 is the complaint filed by me, these are the documents, exhibit so and so. It's still not authentication.
so
Authentication comes when the document is proved to be a genuine one, right? Okay, you all can look into this, okay? Even I authenticated it, but I dislike that procedure because the whole point of this filing of affidavit came here. Actually, I was impressed by one of the judgment. I think we'll get that later on, which said that affidavit can be filed. Why? The reason is to finish the case at the earliest. It has a 6 months time. And then it came, actually it was already a summary procedure which we were conducting. Is even summons trial, we usually conduct it as a warrant trial case, which is absolutely wrong, right? Except where you feel that this case should be tried in a summons case manner. All NI cases have to be tried summarily. And what does it mean? Summarily, you don't have to write lengthy judgment. Points for determination, just reason for your decision, finish 2 pages it's actually. But we have that habit of writing whole long judgment like in a warrant case. In our courts, there's no difference between summons trial and warrant trial, which I've always felt. Like hearing on charge is not required in summons case. The substance of accusation. Law presumes that the police bring correct charges before the court, correct charge sheets, but they don't do that. So we are in a fix, and we sometimes need to hear the other side because the charge sheet says something else, not according to law. But law presumes that under 251, the erstwhile, whatever is brought before you is absolutely prima facie correct. Therefore, I can give substantive accusation without hearing and proceed on with the case. And I just have to ask whether you have defense to make or not. So in this context, if you are following someone's trial or summary procedure, also you will obviously ask the accused whether he has defense to make or not. Okay. Is there anything on this, in this defense, in an act? As
Specific defense has
Yes.
to be stated, so you
so
cannot.
specific
just
defense has to be asked to
defense.
the accused in an act. We'll see that judgment. You cannot just make a general statement to him what defense you have to make. If you have, what is the specific defense has to be asked. What could be the reason behind this? This judgment. You are asking to the accused in an act, specific defense. Tell me what is your defense now, before you start the trial. It has to be asked that there is a judgment on this. Many of you may not have followed, but there is a judgment. It came somewhere in the middle of 2008, 17, 18, I'm not sure. The reason is,
So that later they don't.
it's a summary trial, right?
Yes.
What does it mean? It should be compact. Now, if you give accused all kinds of defenses to take as the trial progresses, like in someone's trial or in a warrant case, especially warrant trial case, then he'll be changing his defense again and again. He'll be saying something else in the complaint, and he would be entitled to do that. He has a right to defend, right? Though he has made a certain specific defense, let's say he says, I issued it as a security check, right? And then later on, we don't decide cases upon what they are saying. On the facts we decide cases. Later on you find there was no date on it. You cannot say as a judge, no, he had said security. Now the actual fact I'm getting, what I'm getting is there's no date, right? You can still go by the facts. So that is only for the purpose of putting the accused to a certain corner in an act case, so that he does not frequently change his defenses. Still, even after saying specific defense, if there are other grounds to acquit him, you can acquit him. That you can take as an account while deciding the whole case. See, his specific defense was this. Now he has taken varied defenses as the trial progressed, because you'll be arguing in his favor, right? So you can cut his other defenses. It can be taken as a help to see that he had a particular defense when the case, when the complaint was instituted.
So in the recent judgment which I've asked for conviction, I had asked a specific defense, and Ms. Lady, she said that yes, I've given as a security. And then later she was saying that in her 313 exam, she was saying that no, I never gave it to her. The check was never given. So
Yes.
that's how she changed it. So that was helpful.
So yeah, yes, it comes to help, You have said something and you have recorded it, and it contains the signature of magistrate, where they plead guilty or not, right? You have a signature on it. So it does have a value, though it's not an evidence. Don't consider it as an evidence. But when the accused has stated, this is my defense, then most likely you'll have to stick to it throughout the trial. If not, then it will help you in finding the loopholes. Okay, one practical thing I'll tell, what happens in our courts is, usually these transactions, especially when it involves people, we have a lot of money lenders, which we do not see. There's a requirement of license for money lending. I do not know, some old law may be speaking about it. But we have a lot of money lenders who are lending money to some people who don't have money. And usually the agreements, that's the factual things, but we have to go by how the case comes before us. The agreements which they make are usually for higher amount. Suppose I have given you 1 lakh. You agree to pay me back 2 lakh. Now, I'm in need of money. You are in need of money, and you are saying, okay, I will just say to you, okay, I'm giving you 1 lakh, but let's write 2 lakh. You have taken 2 lakh, right? Now, there are certain this type of money lenders, even in our place, then you give me the check, blank check. Then the agreement is of 2 lakh. Later on, when you don't return money, I know you will not return money. You don't have the means to return money. So I'm taking advantage of that, and I write 2 lakh when you have not paid back. Deposit the check, it gets bound. The accused comes in the court and says, no, it was 1 lakh, but the document says 2 lakh with both the signatures. So that is another practical aspect which you can't do much about, because the document speaks for itself, right? So they usually take these defenses, but they cannot do anything about it because there's no evidence to prove. And the witnesses usually come and say that, whoever signed in that, promissory note, that I do not know what they did, I just signed it. So witnesses will be of less help, but if the witnesses say, no, the actual amount was 1 lakh, not 2 lakh, then you might, there may be a chance of acquittal. Still, it may not be, because whether 1 lakh or 2 lakh, debt is a debt, one of the ingredients, all of the ingredients will be fulfilled. So practically it happens that way also. I've seen a lot of cases where people have, you feel it as a judge, you know it. Everything need not be told you. You just can look at the witness, the demeanor, the way they are deposing, you know what was the actual fact, but you can't help much because the document speaks something else. Usually you find these cases in small amounts, like 2 lakh, 1 lakh, 50,000, right, 5 lakh to a great extent. There are middle class cases which about 10 to 50 lakh. Then when it involves a company, it goes to crores. So these things are also happening out there. As long as I was in the court, I had so many cases where the accused was pleading it's not that amount, and I never took that amount, but the check and the document speaks something else, right?
So what if the witness it established that it was double the amount and actually it was just 1 lakh, then later the conviction, the ingredients are established, then what shall we conclude?
See, one thing you'll inquire in this case is during trial or while analyzing evidence is why did the complainant did so? Why did he not come with clean hands? Right? That is one aspect. Second thing is, if it was issued to pay the debt, no matter complainant may not have come with clean hands, but other facts are established that this was the debt and he had to pay that, you can still convict, I believe.
On the 2 lakhs itself or just on 1 lakh?
Oh, just on 1 lakh, I would say that. Because if established it was not 2 lakh, how can you do that? From that 2 lakh you are getting the debt of 1 lakh, that's true. The accused probably would admit that, right? It still depends on some unforeseen circumstances that may come, but what I can foresee is you can still convict on that, notwithstanding the behavior of the complainant, right? Once the ingredients are fulfilled. Unless you find it so, unless you find that it causes so much of miscarriage of justice, if you convict the accused. Right? And we can go for it, giving our reasons that, clean hand man, we can always write that, what we have to write. Okay, a security check. Rohini, you have done many cases. Tell us something about security check. Usually this is the defense taken, okay? The check was given as a security. And I'll tell you one very interesting case of a financial institution. How they, loot the customers, especially in vehicle loans.
The difference of security, the check being given as security is no longer available. I think Honorable High Court of Sikkim has also passed a judgment.
Can you tell me?
Yes, sir?
Can you tell me what's that?
I cannot remember, sir. But
On what grounds?
When a check is given as security, it is not a defense.
Why?
I can't forget, but it was by our High Court and it was...
No, I don't think so. I have never read that. But still, we can clear this.
So I read otherwise that even if a check is given as security, it is given for payment. So
That I wrote.
liability is there.
Once I wrote it, it has not been tested so far. I'll tell you the peculiar facts of that case also. No, I think security is still a difference. Even the law says so. Yes. Different. We will not go by AI, okay? It tells all sort of wrong things. Especially Google AI. Don't believe that. The first one which comes. Because not as a defense, security checks are not given for legally enforceable debts or liability. So if you can show me a judgment opposite to that, I am unaware of it. I still think that security is a very good defense in act cases. Because it does not fulfill the ingredient of legally enforceable debt. I did not give the check to enforce the debt. Of course, we'll come into some finer points on this also. Or to pay the liability. It was given for security. In one of the cases, what I said was it was never tested. Though the parties, the other side had gone to Honorable High Court, but they compromised in between and no judgment came on that. What had happened was Just give me a minute. What I said in that case was, if you are giving something as a security, what's the purpose of security? Is it just a piece of paper that I can keep it as a security, or I should be able to use it? Suppose you take 5 lakh from me, you give me 2 lakh as a security check. You may not say me in so many words that I can deposit it to discharge that debt of at least partial 2 lakhs. We may not have said in so many words, we may not have written in paper, but what will I do with that paper then? What's the security purpose? If I can't use that check given by him at all as a security, then why should I even take it from him? I should be able to deposit it, was my view, okay? So it was argued in that manner, but in that case I did find that it was not given as a security. My finding was that, that's why I spoke about this, right? But if you're finding it as a pure security, where there was no intent or no agreement or no, similar intent between the both that, okay, I'll use it, then it is still not a defense. Because many cases have been acquitted on the ground of security check.
So the decision which I was talking about is Runa Kumar Guru.
Oh yeah, I know this case.
Counted further, but I may have
This has not decided.
Yes,
It was this case.
The meaning of the term security.
Yes, no. I know this. This went from my court. So in this case, what had happened was, what I had said was, which the appellate court did not agree, that there was a transaction between two parties. Transaction in a sense, he was some kind of a broker, who would help people invest in mutual funds or something like that. So he took money from me, promising me, let's say about 10% return. I forgot what is the percent. Then later on, he does not return me the money. And I say, you took money from me to deposit in my name in some schemes, and you have not returned to me. So he gives me the check, and it bounces. I claim it, and he says he defended as a security check. What I see, even in High Court, they continue to say security. But my view was, it was not a security check, but I had given the money to him voluntarily. My view was that, in a sense that I was investing in a scheme, hoping some returns. Where does the debt arise? Was he indebted to me in that account? I was voluntarily giving him money, saying go and deposit in some schemes. If I as a person would not care about what is the schemes, what is he really depositing or not, it is none of my business. Neither he had mentioned in complaint. He has simply said he had taken money to deposit in schemes, and I had given it. He did not return me the investment as I had desired, therefore he has a debt or liability, it was said. Okay. My view was, he has neither liability nor debt, because I gave that money voluntarily, hoping some good returns. So where's the debt? That was my thing. It was set aside with saying that it was I really don't remember the ground, but security check, he took defense in the High Court also, saying that it was security. Even my finding was it was not a security check. So this case, again similar case was there of the same accused. This was the third case, the complainants were different. In that case, he again said that it's a security check. In that case, again I said that the piece of security doesn't mean a piece of paper. Once you have given it to me, in the context of that transaction, I was entitled to deposit it, and there was a debt. Okay. So security is still a difference, but it has to be a pure security.
Right, sir. I take a statement back. I think I misinterpreted the observation. I think the term security was explained.
Yes. Because he had taken that defense. No? So a pure security amount intending no debt or liability is a defense in an act, if I can prove that. But there is a presumption. One thing we should be very wary about is 139 raises a presumption that I have committed the offense because there was a debt or discharge of liability existing. Now as an accused will have to disprove that. Okay, so usually you begin with conviction unless accused can bring something in evidence. Usually you will have defense evidence in NIT cases. They'll bring evidences.
They'll have to even disprove the presumption under section 118.
But it's not just necessary that, accused has to come to the dock or bring witnesses. From the complaint itself also, if you can find that there was no discharge or liability, then you can still acquit the accused. The rule is preponderance of probability, right? So these provisions are not required to be there. Offense by companies will see like a notice. Okay, Rohini, or anyone on notice. This is also one of the litigated part. I'll tell you one interesting case on this notice also, where I had to acquit the accused because of something. Which is the most prevalent judgment in delivery of notice. There is one called CC Alabi Haji, 3 judge bench, which says that once the notice is correctly addressed,
It is deemed to be served.
it's deemed to be served, whether you get it or not. But there is one MD Thomas case which says that in its fact, where it says that its fact was the notice was delivered to the wife of the accused. The Supreme Court says that's non-compliance of the provision, but that's a 2 judge bench. She is just CC Alabi Haji is a 3 judge bench. Our Honorable High Court has held that MD Thomas is per inquiry.
So,
Those cases are still pending in Supreme Court.
I have one though.
I have one case right now.
Yeah.
So
Yeah, let's say.
the thing is, the notice is dated, let's say today, but the receipt is of a back date. The postal receipt is of a back date. Actually, they mismatched the postal receipts.
Could
They
be.
put a wrong postal receipt and the postal receipt is of a back date.
Okay.
I'm thinking.
Then what the complainant are saying?
There's no explanation from the complainant so far.
So you can
So
still-
the accused is saying, I have not received any notice. Look at the
Yeah,
notice, the
obviously,
date
take
is
advantage
also
of that.
different.
But you can read this CC Alabi Haji judgment. But there's a little bit. In my case, what had happened was the address was correct, but there's no evidence that the accused received it. But there is a presumption which says correctly addressed. But it had its own facts. Another thing I'll tell you in notice is what had happened in that case was accused used to reside somewhere in Chanmari somewhere. But in certain criminal case, he was in wrong date. So the notice was issued to wrong date. So I have said that it is not a correct address because there was no proof of delivery also, whether the accused got it or not, right? No proof, nothing. So I said that's not a correct address, even though he may have been there temporarily, that's a fact. So I could not raise a presumption because that was not his correct address. And there must be some evidence. I can't presume jail address to be a correct address, right? Unless someone comes in evidence and says he was in jail and so on and so forth.
So if we presume that notice was issued and thereafter it was received by the accused, but then how do we calculate the date?
Yes, and I think General Clauses Act, what's that? 27, I think. 27, no?
27.
We go by that. We take a reasonable period of time. If it appears to be reasonable, then I think that's acceptable.
So if it is presumed, but then to calculate 15 days of receipt of notice and then with the payment within 15 days, so as to calculate the period
Yes.
1 month for filing complaint.
Usually
We need exact date of receipt.
in such cases, usually the complainants do mention the date. They assume one of the dates. But in that case, you can take a reasonable period of date and accept it. There is no course.
None of the accused have, in my court, they have not challenged. But then I wonder if
So how
they
you
challenge.
calculated? You must have calculated.
Yes, so because they have not challenged. So it is.
No, in any case, you give one date. No, that means.
Complainant states whatever the complainant must have written in, then she must have
Yes,
calculated.
yes, that is what it was. But also not challenged.
Yeah, if it's reasonable period, then you have to take that. There's no
But
other
if it
option.
is
Otherwise,
not mentioned-
almost all the cases will fail because the post office, they are not giving the acknowledgement cards. They don't give one. God knows where it goes unless you search it, and they bring printed form of that shipment tracking. Again, it has to have 65p. That's the biggest problem. If they come with 65p, otherwise, how can you admit that? Then? Right. So notice there are lots of judgments that it can be presumed to be delivered to the accused if it is correctly addressed. But I think, what is the correct address? There must be some evidence on it. Just because the complainant says this is his correct address, it may not be. But courts have held that accused have not denied those addresses. Therefore, the moment they deny, I think they should bring evidence. So it's a very different law as compared to other trials which we do, right? We don't look for proofs. Usually, we forget proofs in NIA cases because there are presumptions. But there are judgments which says criminal law, criminal cases have to be proved beyond reasonable doubt, and it applies to NIA cases also. So it's a very, it needs a lot of practice to be very expert in NIA. Otherwise, we forget certain things. We may try to look for hardcore evidence and there is a presumption. So we may only rely on presumption and forget the requirement of evidence act.
So, because of beyond reasonable doubt, I'm having a confusion in one case. Now, what has happened? In the legal notice, it is written that you issued me check saying that, it should be deposited after 1 year. That is
But
the story.
validity won't be there.
That is the story but check is dated.
Okay.
You can present it only after 1 year. That is the story in the legal notice. But in the complaint, there is a different story saying that money was borrowed and despite of requesting you, finally you issued me check. That story is different. So
if the story is different, yes, and you find a really loophole that can destroy the case, I think you can acquit because legal notice is the document made prior to complaint. It does have some value.
So, but then all the ingredients are being fulfilled. But this is that the story is a bit of mismatch.
If the mismatch is not explained, then you still have a right to, say something on it. Because even I acquitted one case on the basis of legal notice, because that was a prior document, but in my case, absolute contrary things were said. So, I acquitted on that ground, and that was a big case of acquittal also. People, checks were issued actually, but people dealing in businesses usually, they have so many businesses with each other, and when things are not going right, they just produce the check and put it in the court. It's not something that we are there to deal with. They're all civil transactions. Sometimes you get so furious in NIA cases. It's purely a civil transaction, and these people come in with big files and evidences saying that this had happened, that had happened. There was a transaction of land and all. But these people actually are business people who, if everything goes well, have no problem with non-payments also. But when things go wrong, they deposit the check and come to the court, and there's enmity between them. So most of the times I felt this should not have been a criminal offense. People dealing on their own civil side and coming to court and harassing the court, needlessly clogging the courts with all these cases. And in fact, most of the jurisdictions like New Delhi, I think in Bengal also, or some other places, there's a special magistrate who deals with NIA cases all day. Right, and it goes on perennial for many years. That post is there to continue for many years. We don't have that, but that is just because the legislature has made, I don't think for any sufficient reason also, these offences as criminal offences. But as I said, law presumes some genuine justices to happen, right? But in our country, in that merely everything comes in and we have to decide on that. But genuinely dishonor गर्दैछ भएको हो भने त त्यसको लागि बनाएको हो नि त law. But जानी dishonor गर्दैछ. And one more interesting thing that I am telling from my experience. Notice everyone here? Okay, don't forget the presumption. Insufficient funds is a genus. There are lots of species on this. Even signature mismatch can be brought up. There, whatever can be a species of insufficient fund. So just don't see that it says insufficient fund and bank arrangement exceeded are the only grounds. There are a lot of other grounds where the case can be initiated. Signature mismatch, what it could be? Dormant, they are using something. Okay, dormant account. If I have not used my account, still I am issuing the check, I am still liable. Though it is neither insufficient fund nor exceeding arrangement. Okay, so whenever a different ground is shown to you in your court, look into the judgments and peruse a bit whether that ground is covered or not. 99% it's covered, but sometimes we can't predict on facts and law. It may be totally different and you may have to apply your own mind. Tea break, 11:59. Now these two are distinct things, right? Now one interesting question has come. Income Tax Act, what is the code? Jabian would know Income Tax Act very well. 269 SS. You can't transact for more than 20,000 in cash, right? under Income Tax Act. Yes, yes.
Cash
20 lakhs. 2 lakhs. 2 lakhs per year. No, no, not over the year. Particular single transaction. Okay, 2 lakhs. Then what if you have transacted in cash for more than that? Is it a legally recoverable debt? So far, I had one case. I have said it is legally recoverable. I relied on several High Court judgments. In an SS in Income Tax Act, she said 2 lakh. If you are transacting any 2 lakh or 20,000. What is this? 20,000. It is 20,000.
Does it not 20,000?
I don't think so. There is a recent Kerala High Court judgment also which says 20,000. I think what you all are talking about is the higher the cumulative amounts. In a single transaction, you cannot transact for more than 20,000 rupees in cash. Digital India, no? And I'll show you one judgment. Please don't laugh or say to me anything. Just keep it in your mind, so. This case has gone to Supreme Court, but I'll show you. When the Income Tax Act 1961 prohibits a person from taking or accepting from another person any loan or deposit or any specified sum above an amount of rupees 20,000, otherwise than by an account paid check or account, or so and so, whether it is a legally enforceable debt. Kerala High Court has said it is not and updated the accused. And I do not know why this is written. You all can read it and keep it in your mind only. This is the another paragraph. This is in the dream of our country. So just keep in your mind, I don't want to say anything on this. Accused has to be updated. Because it is not a legally enforceable debt, because it is something prohibited by law. The person had transacted more than 20,000, right? So what's your view? Now the case is before Honorable Supreme Court in special leave, but let's hear views of you all. You can have it.
If it had been made into an offence, then it may not be.
Offence, no. In an act, there is a penalty. In Act. You have to pay, I think, double the amount.
If it's just a fine or
it can be tried in court.
Fine or a thing, and not an offence, then I think it will be legally enforceable.
Yeah,
but if it is an
offence,
made an offence, then I think it will be illegal. Not a legally enforceable. Even Contract Act.
Accused is saying I will double your party to me.
Involving offences cannot be enforced. So
see, the accused side is arguing it's a double jeopardy if you try me on court. Okay. Complainants are saying that since that particular transaction is dealt by the other act itself, okay. Now my claim of dishonor is dealt by an act, it has got nothing to do with the violation. And this act says it does not punish the giver, it punishes the acceptor.
The double jeopardy when one is punishing the accused, other one is punishing the receiver. How can it be double jeopardy?
That's what they are arguing. No. It's the receiver, no?
So in one case, the receiver is getting punished. In another case,
Who is the receiver?
the complainant
Receiver.
of an act in income tax. It is the complainant
Is it?
who is the receiver.
Is it? Suppose if I give Jabian 20,000, he is guilty and not under more than 20,000 under an act. Now there can be a situation.
I think
Let's see the fact. They have argued double jeopardy. This also, penalty is imposed on a citizen for the violation of a provision and to prevent him from repeating the same in future. And it is not a mechanism to get money to the revenue. In other words, if the criminal court indirectly legalizes such illegal transaction in violation of 1961, the same will be against the aim of our country to discourage cash transactions. Could be correct. It could have been said differently also. Whether it's legally recoverable or not. like money from gambling. If you are trying to pay the gambling is an illegal act, right? You try to pay, then you should check and it gets bounced and the complaint comes and says that it's a debt, it's not a debt. It's not legally recoverable. But in this case, in this income tax act, if there is a debt, suppose I have paid you more than 50,000. I have given you, let's say, a debt, and you repay that back in check. Now the question here is whether it's not legally recoverable or not. We are just looking into the Income Tax Provision Act, where the receiver is the offender in that act, right? But he did owe debt to me, which paid back through check. Now the question is, my source of giving it is beyond the provisions of Income Act. Now, would so much of it make it legally not recoverable? Because there will be so many transactions, just because it's a digital aim to, enhance digital transactions, does it mean that there's no debt? So, do not know what Honorable Supreme Court will say. It can be said anything, can't predict it. But if the judgment comes that those things becomes not legally recoverable, then things are going to be very difficult for those who are transacting illegally actually. But there are judgments which says if you have not sold in income tax while paying the income tax, then that cannot be recovered. You must show it. And source of income company also, though that's not the main criteria to judge whether it's legally recoverable or not. But sometimes showing source of income becomes very important in the facts of the case to reach a conclusion that it is a liability, right? Though by itself it may not, because in the complaint, you need not talk about source of income and all. The ingredients are he owed a debt, how, and therefore the ingredients are fulfilled, he is guilty, he has to pay that. But in some cases, source of income does come into.
Sir, I think when the accused challenges the source of income of the complainant, it is incumbent upon the complainant to.
Whenever there is a denial or challenge, the complainant can always bring in additional evidence. There is no problem. We will not prohibit it. So, depends on the facts of the case. There will be a lot of argument on source of income also. That a person who has no income, the accused alleges, has given me 10 lakhs. How is it possible? Therefore, I owe no debt to him. These are the defenses they take, okay? And in some of the cases, it becomes very vital. If you are finding somewhere the person has no source of income, obviously you must show it. And coupled with other facts where you are doubting whether he did transfer him the amount or gave him the amount, then in such cases it may become important, the evidence on source of income, but it may not always be so. Just because source of income is not shown, you need not have a finding that the accused did not owe the liability to the other person or debt. So the debt or other liability defenses are the main contesting factors in the denied cases. And there is a interim compensation also, I think, which came much later on. You can direct payment of interim compensation to the complainant pending the conclusion of the trial. And usually it is deposited in banks, or you take certain security from the complainant that if he loses the case, then you have to return back. Okay? I think interim compensation, is it mandatory?
It's not mandatory.
If the complainant claims, then what are the grounds on which you can refuse?
He cannot show that he's in need of money. I have rejected one case where it was the cooperative bank which had claimed the interim compensation, but because he could not show that he was in need of the money, I have rejected.
It says so.
So there is, I think, we can.
143, no? No.
142A.
142A.
Okay.
142? It's in proviso, no?
Oh, it's 143, yes.
That's so. Said to may order, okay, in a summary trial or summons case where it pleads not to institute the decision making complaint, and in any other case, in any other case upon framing of charge, why does it say so? When we are sure it's a summary or summons trial. We see 143A. Notwithstanding anything contained in CRPC, you can read it as the new law. The court trying an offence under section 138 may order the drawer of the cheque to pay interim compensation to the complainant in a summary trial or a summons case where he pleads not guilty to the accusation made in the complaint, and in any other case upon framing of charge. When is charge framed in this case? 138 के complaint में 420 try करता हूँ क्या? It's a complaint. You can carry on complaint case under whichever offence, whether it's a warrant trial or summons trial. I can always complain to the court. Whichever are punishable for more than how much? 2 years. Those are warrant trial cases. I have the right to complain on the CRPC. It change action, Madam Judge. So if there is a case of 138, can I plead 420 in a complaint case? Both are complaint. I think yes. What bars it? So I think it's taking into consideration those cases where it says in any other case upon framing of charge. So if there is a 420 and 138, I'll have to frame charge. One is a warrant trial case.
So, but the court trying an offence under section 138 is written.
Where? Where is it?
So, notwithstanding anything contained in the Code of Criminal Procedure 1973, the court trying an offence under section 138.
Of course, I think it's only trying to mean that you can give compensation under 138, not for other sections. Is there a bar in trying 138, 420, or what it could be? Misappropriation, all can come together. Usually 420, 138, usually if you go deeper and if one can plead, one can always plead 420 GB. He took money, deceiving me with a promise to return back. Obviously attracts 420, the erstwhile 420.
So then rule of evidence should differ, sir?
Yes, for trying as a warrant trial. Rule of evidence.
Regarding this.
Procedural processes differ. How rule of evidence differs in a warrant and summons?
No, under
As affidavit.
138 and other offences regarding presumptions.
Yes, for 420 you can't draw presumption at all.
So can we convert the summons trial case to a warrant trial case under 138?
As per older CRPC, we cannot convert. But it is not conversion, no? We are not converting, we are taking cognizance and framing charge. That's not conversion. Conversion is when you are, if it's a warrant trial, you can always convert into summons trial. No. Summons you can convert into warrant, right? Not warrant to summons. But that you will be giving reasons and saying, I'll try this in the procedural form of warrant, right? So that is conversion, true. But in this case, when you are taking cognizance of the 420 and 138 and decide to try it in a warrant trial manner, that's not conversion.
So if one of the offences is warrant
To
trial,
explain this charge.
so for 138 also charge has to be filed.
Yes. If you are framing charge, all offences will come under charge. I haven't seen any bar, you can still ponder upon it. I haven't seen any judgment also with bars. In fact, there are cases of the appellate courts which talks about 420 and 138, not in that particular context that whether it can be tried or not, but in the context that both cases are tried, none of the appellate court have said this could not have been done. I think it's possible.
So again, we don't.
And you'll find quite a number of complaints where 420 is also added. What I used to do usually is tell the lawyers and all, why are you complicating the process? Give up 420. But some would not give up, so I think I have to take it to its logical conclusion. So usually lawyers agree.
So if
Okay, but record this
expeditious
submission.
trial, no, sir? If other charges are also attached, then it would impede
Yes,
expeditious trial.
that's true. And 420 would be quite complicated also in a complaint case. It is ordinarily something which ought to be investigated. We would not be having evidences also in the form of that can be gathered by way of investigation. So otherwise there is no point of mentioning here in any other case upon framing of charge. Context is identical.
What's the point of having an
No, it's not, every time it won't be like that, no, but we can't leave a law not to cater to a certain situation also.
If it is warrant track, then you have to follow the
maybe
NSS procedure.
Case is
Yes.
complicated, involving a lot of evidence, then maybe we can convert it into a warrant case and
No, summons can't be converted.
then it came to charge.
That CRPC used to say, the summons to warrant. No, but that summons trial is sufficient. Why it warrant?
Because even in,
Okay, I got your point. That's also a valid point, something to be considered. But what bar is there in trying 420?
There's no bar.
Process is CRPC only.
So I just have a question.
Yes.
So the 423 complaint we got it on person. After it, okay, after it.
No. Okay, when they are not interested in complaint cases, unless you find it will cause prejudice or miscarriage, why to add 420?
then the evidence will come in affidavit and all. So I think that for 420.
Evidence given, no?
Evidence on affidavit of occupancy, maybe 420 is not used to that.
Yes, no, when we go by trial of cases in a warrant case manner, then obviously we'll do away with affidavit and all. There are certain cases where 420 is pleaded. Probably, I don't remember, I think I have taken cognizance when the lawyer refuses to drop it. Because you can always have a talk and very complicated, because the accused would not know, the complainant would not know. Unless the complainant, we have certain complainants or even accused persons who are well versed in what is being done in the courtroom. But generally we don't have, so they have no idea about what the lawyer has put in before the court, right? So it's upon the lawyers only to say, okay, I forget about 420. That requires a different set of analysis and all. The combination does not match actually. Okay, but I see no bar. Okay, intention. Whether intention is material in an act.
It is not.
So I think not.
Yes. What if you have a finding of intention also? There are chances when you are analyzing evidence. You do find that the accused has deliberately drawn the check knowing he had no money in the account. That's not the requirement of law, but what if you have that finding? Does it make a difference in the case? I have had that finding in one case.
Adverse inference.
Clear finding that the accused knew there was no money in the account. Because an act is actually, it gives you the chance to repay it. Right? It's actually meant for, where you were unaware of that the drawn amount does not exist in the account. It should cater ordinarily to those situations, not knowing you, otherwise 420, I go and receive it. Whatever it is.
Also, we give them the opportunity, whether
That's
you want
what.
to pay or not. I mean,
And there are judgments which says even if the notice is not delivered in your case, the accused person receiving the summons and coming to the court is sufficient notice to pay the amount. He could have asked for 15 days from there also. So see that also. Okay? There is a sufficient notice, it says. Though it brings down the ingredient of the offence, but it has been said. So the main intent is to pay back the amount to the honest drawers of check actually. What if you find the drawer was dishonest too? Though not a requirement of the act, does it help? Yes, it does help, in reaching a conclusion. Forget about presumption. You have a fact on hand saying that he did it deliberately. Therefore, it adds on to your conclusion that he is guilty.
We can be strict in sentence.
Yes, that can be. I have had one case where clearly I found that he had no intent to pay the amount despite you drew the check, there was no money in the account. Okay, so that finding of intention does help you in reaching a conclusion very easily. Not only did he draw the check, but he was a fraud too. So in that context, intention is material. Otherwise, there is no need of looking into the intent or knowledge in reaching the conclusion that the accused is guilty. Okay? Drawing of check, his signature proof is finished. And usually in some cases, accused person as a last resort do come to you asking for sending to forensic these signatures. And I think you are bound by allowing it if he has raised the dispute. That's why the specific defenses are very essential. If the accused had said something else, and not of the signatures. I, as a judge, in the middle of the trial would not allow matching of signatures unless I have very firm grounds to see that I need to check it, because his specific defense was different. So these are also the reasons why specific defense is asked. In the first he says there was no debt, in the middle he says it's not my signature. Why should I send it to the forensic? That was not a specific defense. The appellate court may allow it to foster the ends of justice, but I, as a trial judge, would outrightly reject it as a, as a plan to delay the trial. So here asking of specific defense becomes very important. Let's go to attention. Then in one vehicle loan case, I often found that I do not want to name the financial institution. Lot of cases it used to file on the NI that to pay the installment, the accused gave the check got bounced, and therefore is liable. Now, most of the financial institutions, what they do is, even if you see, they ask you for checks. They usually ask for cancelled checks. Okay? It is just for the purpose of verifying whether you have account or not. And today everyone can have checks. If you apply for it, you get it. In the earlier times, I don't think everyone was eligible to get checks. You may have had to certain amount in your account. Nowadays, we get checks. So when you give a check, a cancelled check, it's a proof that you hold an account. It's a proof that you are a person who is capable of transacting and do user transactions in the bank, right? Its purpose stops after that. But there are certain financial institutions which charges quite a huge amount of interest in the loan. They take checks from the unsuspecting customers. Usually they insist on it. I need a vehicle and the institution is willing to, even 100% finance you, and then you are happy. You think that I can pay somehow, I have small business, something. But sometimes you fail, right? Most of the times you fail, those small business people. But they like vehicles also, so they take it. Okay. Sometimes it's just for the purpose of show off also, people take it. And they are unable to pay. And what the bank does is, it completely fields the check and presents it to the, sorry, not the bank, the financial institution, to the bank. It gets dishonored and then a case comes. Now, how I did discover this was, there was one case where the lawyer asked the complainant bank manager that, what is the process when the loan is defaulted in a vehicle loan? He explained, they take the vehicle, auction it and all. And then next question to him was, did you auction it? And then he knew he would be in trouble if he answered that. The vehicle was sponsored, I had to step in and I said, you have to answer this. But they auctioned it. He said, I do not know, something like that. I said, no. What is the process? By this time, would it have been auctioned then? Under process, yes, it has to be auctioned by this time. So they were caught in that. They auctioned the vehicle also, obtained the amount after auction, and they were still claiming the rest of the EMI. So I acquitted the appeal, saying that they have not claimed the amount that is due on the check. Therefore, there is no case of death or no. Moreover, they lied that they did not, that they auctioned the vehicle. So that was my ground for finding and acquitting the accused. But what they used to do is what I found. Then I called the lawyer and I asked him, you all actually take the check from these people, blank checks, in the name of security, and they feel it and they deposit it. After that,
whenever we are taking loan also, they give us sign a bunch of documents. And
that's what.
Acknowledgement to everything is signed.
That's what. Unless there is a clause which says the check which you have given can be used to, pay the installment, then that case doesn't stand. So maybe some banks have, that particular financial institution did not have that clause. So they were looting actually. They were already auctioned and they were only entitled to the portion of amount. And when does the cause of action begin in this installments? Actually the cause of action begins as soon as the first default is made. It comes after 1 year or so that they give notice only after this is more particular in civil cases when the cause of action. They have tried civil cases also. The cause of action in installment arises as soon as there is a first default, not third or fourth default. Not when they are giving notice after fifth default or not. They should take steps because I think limitation in civil cases would be 3 years. Right? This is not much there. This is electronic clearing system. Like if you have an auto mandate given to the payment of loans, the installments, it automatically gets debited from your account. That is electronic clearing system. It happens in bulk. Okay, there may be so many loanees in the bank. Date is fixed on that particular day. Automatically, the computer transfers the fund. But for this, there is an online process. There is an offline process also. How you register for electronic clearing system. Once you register your account for auto debit, then that particular account gets debited exactly at the same time, same day, same date of every month till the entire loan is cleared. FT RTGS. RTGS is usually for use amount. There is a settlement instantly. I have not done RTGS online so far. On RTGS I have conducted offline. You have to fill certain form, but online facility is also there. Today, just to know whether I can do RTGS, I just checked it. It said that my limit is 1 lakh for RTGS online, but anything below that was also not worth it. Right? NEFT, it takes time. NEFT is also done in bulk. Suppose there are 10 NEFT transactions of different customers in a bank. Every hour or quarterly, I do not, it may vary according to the bank, the NEFT transaction takes place. So at least for 30 minutes you have to wait for NEFT. Okay? The difference is only this. All are transaction and from one account to another, all does the same. E-check, digital check, I have not used it personally. I have to do a little bit of research on this. You can have an e-check, just a digital replica of physical check. Now, how is it relevant in an act case? If there is no physical check, nowadays we are still getting physical checks in courtrooms, right? So I found out that once there is a check bounce, a SMS comes to the person, the drawee, that the check has been bounced with check numbers and all. E-check, we haven't seen any prevalence much out here. Maybe in high-end cities, their e-checks are being used more. But if you see, even when you read judgments, you don't find e-check cases. Probably because e-check is real transactions are taking place without bouncing. I'm telling you, these check bouncing cases most of them are intentional. If it was not intentional, or there would be no litigation if it was not intentional. I would pay it. Oh, I'm so sorry, I forgot. There was no money in the account. Now I have money in the account, I'm giving it. So physical checks makes it more easier to fraud someone than the digital check. You get instant information on digital checks. And digital checks are not being used by common people. I think it's being used by big firms where genuine payments are being met, so there's no litigation. I have only found one case which talked about e-check today morning while checking. Actually, it's fraudulent. Wherever check is bouncing, it's fraudulent. Otherwise, I was in Gangtok for 3 years. No one came to me and said, oh, it was due to mistake, I paid. No one paid it. Confusion on that one. Or sometimes they ask for Lok Adalat and they waste your time. Really, sending to Lok Adalat these cases, to my understanding, they waste time. Afterward, it comes in the same stage and you have to start from there. And they are such kind of people, again they will ask you for more 2 times like Lok Adalat. And then when everything else does not work, they start talking about mediation. Of course, some have settled, 1 or 2. But on the larger part, it comes unsettled back. And in one case, they settled in Lok Adalat, again that check also got bounced. And they filed it before me.
Same with me also. Like in Lok Adalat, the other party issued check and then bounce and again NI complaint was filed.
I do not know, that time I had to think a lot.
So one thing I noticed, after they go to the mediation, sometimes they settle the matter and they come back.
Yes, sir. Even I have noticed that in
What happens is like you already have an NI case going on. Now why would they again go to a mediation and enter into? They are sent to mediation, they settle the matter. Now the complainant at the most has a civil contract which he can again go for specific performance. His remedy lies only in that he cannot go for execution of that agreement He has to file a civil case for specific performance. He'll get a judgment, then he'll go for execution. Such a long procedure.
I still didn't get it.
Because
There's a 19-year case, it's referred to
case is
mediation.
going on in my court. Now the parties want to be referred to mediation. They go to mediation.
Okay.
They settle the matter also. They have entered into a contract, mediation agreement.
Then you pass it.
Now look at the state. Then the case is.
Then what you do as
pass-
an act court when it comes back to you?
Then the one of the terms is to
Yes, in
withdraw
court.
the case. They withdraw the case.
Oh.
And the payment will be made within certain time or whatever. That sort of an agreement they get into. So look at the status of the complainant. Out here he is having a bounce check. He has the right to put that person in jail or get money. And the Kanawala, his status is again changing to that of having a civil agreement which he can go for specific performance and again maybe execute, and it's a long. Actually, he becomes in a weaker position.
What do you say?
I have a similar case in
Because you
the
can't pass a decree as a criminal court.
Yes.
It comes back to
So
execution.
withdraws the case under his position becomes very weak now. Afterwards, he only has an agreement.
I think
Civil
so Ms.
agreement.
Narita has the answer to that.
So actually in my court there's a similar case. What happened is in my local the NI case was settled. They entered into an agreement, settlement deed, and later the accused person did not pay
Yes.
even after they settled it. Now they have filed the case under section 21 of Legal Services Authority Act for execution of that.
No, it is mediation, no?
The effect of
So
mediation-
both the
No, I
parties
understood.
voluntarily want to get into mediation. No, you cannot help it. If
No, no.
they both want
Yes,
to
what-
get
what-
into
This
mediation,
is
and
mediation,
settle
he has
the
no
matter.
decree, he has not given any
Mediated
decree. That's
that-
merely
I
an
cannot
agreement.
pass any decree. At the most,
That's
they can
all.
withdraw the complaint.
Okay.
But the position of the complainant becomes very weak. That's what I'm saying.
The effect of mediated settlement will assume the character of compromise decree. So I think that is executable. So once the matter is referred back to the court and we pass final order, that assumes the character of
But this is
compromise.
criminal court, no?
It is quasi.
Can a order passed in a by a criminal court be considered as a compromise decree? That also.
So otherwise the
Similar to
whole
the
process-
DB Act cases.
Actually, mediation, see, here also one thing comes. These NI cases are not fit for mediation. Lok Adalat at the most, to my understanding. Mediation is a different process, where two parties are very much loggerheads, and there is an element of settlement. Because of some things they are not agreeing. Like family matters are best for mediation. But I've given him money, he's not paying me back. What is there to mediate on this? Unless it's a huge business, implications are there where people really want to settle through mediation. Win-win for both. Lok Adalat is a totally different thing. So the problem is, parties are referring it to take time. They are settling there. I want money, you need time. If I get that, if I get in that, we'll agree whatever be the forum, whether Lok Adalat or mediation. But I know I don't have money. I'm just buying time, right? So I do not know whether where we are referring to is exactly the correct place we are referring. If that is complication, you can convince the parties to go to Lok Adalat. Because if that comes, you can still, they will draw an award and that can be executed because that takes a different forum. But yes, can you explain what you are saying?
So I was explaining.
I said
in
that
the
it might not be a compromise degree, but you can speak on it.
So otherwise then in context of NIA cases, the final order after mediation assumes the character of compromise decree, which is executed. But I am not sure in the context of NIA.
Because after something comes to mediation, the trial court will have to say
Normally in
something.
civil cases, what I've done is when after the parties come back from mediation, they can agree the terms in which the decree can be passed. Then it takes the shape of a decree. Otherwise, just the mediation agreement has no force of a decree. The court has to order a decree, but the criminal court cannot do that. So they can only withdraw it, and the complainant, he has no case then. He has to file a civil case for execution of the mediation agreement. While the specific performance is filed, then after getting judgment.
Yeah, but what she said is also correct, that even if he suffers, he voluntarily suffered.
So maybe the advocates are not aware
that
of
is
the
true.
technicalities
Advocate
and
parties would
they are
not
going
know.
that route.
Then ultimately when in a fix, the lawyer will leave them. Then he'll have to look for some other lawyer who will say, yes, I'll do it. It's not possible to happen. Okay, because when you go to a doctor, they don't say they can't do it. If you have gone to the right doctor. So that profession is like that only. So this much in the slides. I have some, we have practice directions. How many of you know it? Given by the High Court. Doing that, you know, it's there. But our practice direction, I think this. Yeah. This is given pursuant to judgment of Honorable Supreme Court. You can read it. Get this up. I need to increase it. This territorial jurisdiction one, it's applicable not only to an act but to other cases also. But I think there is one Honorable High Court judgment, our High Court judgment, which says that magistrate examining complaint and issuing processes are part of inquiry, and therefore, what separate inquiry do you do? You can't go to the case
We
and
have to insist upon the original documents.
Yes, Supreme Court has
a little bit of do something, that's considered as an inquiry.
Where is the document? The Supreme Court has also
What you have to write it specifically.
Yes, sir. When you still-
And use the word inquiry.
Yes.
I've inquired before issuing the summons. But don't be routine in all the cases. Keep in mind some cases might be different. Where you have to do something different. Because then you'll have to see what powers do you have as a magistrate under inquiry. What can you do? Okay, I think there are powers in CRPC. What you can do beyond what you are doing as a magistrate in inquiry. You can ask for documents from somewhere or do something which you ordinarily don't do. So I do not know who used 258 can be used. It's complaint case. 258 isn't. Someone's trial on police cases. So I don't know, someone may have used 258, then it mentions you don't use 258. It also says that all trial courts shall treat service of summons in one complaint under section 138 of an act, forming part of a transaction as deemed service in the other one. Because in an act, if there are 3 checks dated differently but the transaction is same, they'll file 3 different cases. You can club these cases also going to CRPC that offences with 3 offences within a year can be tried in the same trial on the provision used for error. But yes, if the address is same, the accused cannot claim in another case that I did never receive summons in this case, or notice and all those. Section 258 of CRPC has no applicability to complaints under section 138 of the Act. This is a brief one we have. I'll show you elaborate one with judgments of the High Court. This is a very detailed one of Andhra Pradesh High Court judgment. Filing of complaint and scrutiny thereof. On the day when a complaint under section 138 of the Act is presented, it shall be scrutinized, and if the complaint is accompanied by an affidavit, and the affidavit and documents, if any, are found to be in order, may take cognizance and direct issuance of summons. So, this Indian Bank Association judgment, when I read that, I find that examination of complaint or what authentication, whatever you want to say, is not essential at all. Though it does cause a bit of complication in the procedure. This Indian Bank Association case was one of those cases which tried to bring huge changes in the procedures. Okay, are found to be in order, may take cognizance and direct issuance of summons. Now, in condonation of delay, which I was telling, do you need to hear the accused?
Yes, sir, it is mandatory.
Yes, you have to hear. It's a direct judgment of our High Court also. This is passed on, the judgment is there. It's not in the context of an act, but in a different one. You have to hear the accused before condoning the delay. He has a right to be heard.
So it would be before taking cognizance.
Yes, yes, we are calling him for condonation and not for the case.
One is cognizance is taken and qualification.
Now this also required, there are judgments, avertment that no other complaint filed, because people, there are certain people who live their life on NI. Okay, they are filing cases everywhere. Those, what I do not know the name, those frauds, they are earning money. So they will have to say that it is mandatory for the complaint to disclose that no other complaint has been filed in any other court. Because as I said, there can be two jurisdictions, in a branch and where you deposit it. Necessarily need not be the same places. Okay? So accused will be harassed unnecessarily. Unless the lawyer tells him what is happening, he will not know. He will go to both the courts. Or unless he gets a chance to speak directly to the judge, which normally does not take place. Okay? Otherwise, if you see accused persons or even in civil cases, the plaintiffs or the defendants have a lot to say to the judge directly, but they can't say, and they are already told, do not open your mouth before a judge. Sometimes you need to be very careful and see that if the person is trying to tell something, you can ask the person, yes please, what you have got to say. You can hear so much of it which is essential for you to know. Otherwise they'll speak a whole lot which you should not hear also. So it's upon you how to balance that. So affidavit that there is no other complaint filed in the same case in a different place is also essential. Physical presence of complaint or witnesses in court not mandatory to decide whether or not to issue present. On this side, ANDRA has a specific direction on this. It is open to magistrate to rely upon the verification in the form of affidavit filed by the complainant. Now it's very important to note the word it is open to magistrate. It is telling me, the direction is telling me it's up to you. Not telling don't call the complainant also, right? It is open to magistrate to rely upon the verification in the form of affidavit. This also is there in judgment in the complaint in support of the complaint under so and so. And the magistrate is neither mandatorily obliged to call upon the complainant to remain present before the court, nor to examine the complainant or his witness upon oath for taking decision whether or not to issue process on the complaint. Right? I'll post this in our WhatsApp group. Okay, this one is quite important. Complaint may be filed by power of attorney holder. Yes, we know that. Right? Filing a complaint under section 138 of that power of attorney is perfectly legal and competent. Can prove the contents of the complaint purpose. A power of attorney holder can depose and verify on oath before the court in order to prove the contents of the complaint. However, the power of attorney holder must have witnessed the transaction as an agent of the payee holder in due course or possess due knowledge regarding the transaction. Now this is part of evidence act. We can't depose on what we have not seen or heard, no matter what attorney holder I may be. Right? I must know the facts. Specific assertion as to the knowledge of the power of attorney to be made. This is also he must tell that what transactions he knows by himself. He cannot delegate, of course, that's true. Inquiry under 201 is mandatory where accused resides beyond territorial jurisdiction. So do something, write something that appears to show that you have done inquiry, even though our Honorable High Court has held in certain fact that you are examining the complainant is sufficient inquiry. For such inquiry, evidence may be given by affidavit. Now, if you want to go a little further, okay, for the purpose of such inquiry, evidence of the complaint may be given by affidavit, and evidence of witnesses on behalf of the complainant by affidavit shall be permitted. Sometimes just to verify the address also, because in an act, sometimes the accused persons are from outside and the complainant has given certain address. And you issue the summons, it never reaches, or even if it reaches, it's found that by a person by such name is not there at all. So just to verify the address also, you can give me the address on affidavit. Now you are sure that the person resides there, he has given it an affidavit. That's sufficient inquiry to proceed against someone who is outside your jurisdiction. And outside your jurisdiction means what? Tell me. Usually what comes to us? We are in a small place.
Police station. A certain jurisdiction.
Yes, your territorial jurisdiction, you don't have territorial. We have territorial jurisdiction of Ananchi. Then you will have to do it. Got my point? So don't forget that. We forget our nearby places. Complaint to give his bank account number. Yeah, this one is also. How many of you are doing it? Bank account and email ID has to be given. This is also in the judgment of meters and instrument. I have done this work. The purpose is that, for a genuine person who wants to deposit, you can write in summons also. This is the amount. If you pay on this, you need not even come to court.
I have done it, sir. I have done. In the summons I have mentioned it. You did not.
So, email ID, if they have, the moment they appear before you first time, you always ask for bank account, okay? And in summons, you can write that. So, they will not deposit, but that's a duty. Here, it shows that you have done your job. Alright?
In my case, they have deposited.
Okay, then that's very good.
Statement also given in the summons that it is a compounded document and you
Yes, yes, that's also their object. Every complaint filed under section 138 shall be initially registered as a summary trial case. That's the usual course, Indian Bank Association and so on. Unless the judge or the magistrate says that no, I am going to try this as a summons case for these reasons. Magistrates should adopt a pragmatic and realistic approach while issuing summons. Summons must be properly addressed and sent by post as well as by email address. You can do by email also. Even by the complainant, right? And who has to give this? Complainant has to give the bank account of the other person and the email, if he has. Usually he has. Court in appropriate cases may take the assistance of the police or the nearby court to serve summons on the accused. Sometimes you can request the police also. In one of my cases, it was just for police 2 lakh, the accused was somewhere outside Mumbai. The complainant himself took the police flight. He lost more than what he was to get. Then I advised him, along with the lawyer, forget it. You lose more, I can't do anything on this. Every time police wants to go, now someone's the layer. Okay, they did not find him, but delivered it to someone, and again, he did not come. A bailable warrant also there. Now non-bailable, the complainant was saying, I don't have money to take police anymore in flight. Police enjoyed a lot. Because in police, they don't get TADF for all these things. Fund crunch, I do not know why. Sometimes, if in East you say, the summons are not delivered by the process servers.
Yes,
One of the main reason is they will speak out to you when pushed that he has so much of pending TA and forget about TA to be paid to him, and he is using his own money to deliver summons. That was the actual problem, therefore I could not do it. Okay. So this is the reality also.
There are 6 cases pending.
How long a constable who is already under loan, they usually have loans, they have made building or something house, okay, so nice of them, and then police, the higher equivalents wants them to deliver summons to a place on their own fund. So obviously they will not. But probably this new system will.
Yes, sir. It's an electronic
Yes, yes.
system.
But on the police side, they are still going. They are still delivering physically because they don't have that application to deliver it online. And they have a different concept of online, which is not matching us. So they are thinking WhatsApp also is online, it's delivered.
Oh, that's what they do that. WhatsApp, right?
If it's delivered and someone comes, no problem, ignore it.
They don't come. And search WhatsApp, but it's not WhatsApp.
Because of this new law, because of the new CRPC, there are certain provisions where, I think state government or someone, if they declare WhatsApp as valid service mode, then it's acceptable. But if they have to declare it.
The question is, so if they don't you send a BWA.
Yes, you can't do much if it's a WhatsApp delivered, and what can you do? That's not your usual mode of service of summons, and upon which we can use law. But of course, if you see in this case, and you can always use at least BWA, but I would suggest refrain from using NWA if it's a first delivery is to WhatsApp, and sometimes warrant also may be through BWA, at least BWA through WhatsApp. They might do it. They think online means they can do anything. Okay, at present they are having that conception. Because on the police side also, digitization of their processes is being taken extensively under their own project. Summons to indicate compounding of offence, which is said, though they will not understand anything what you have written. Summons to contain amount to be deposited for closure, yes. This is the amount that bank ID and email ID. Same thing. Service of summons in one complaint forming this also was in our practice direction also. Court to direct accused to furnish bail bond. Court should direct the accused when he appears to furnish a bail bond to ensure his appearance during the trial and ask him to take notice under section 251 of the CRPC. Now this is summons, right? 251. CRPC to enable him to enter his plea of defense and fix the case for the defense evidence. See the process? It directly goes to defense evidence. That's why I'm saying authentication If you go by Indian Bank Association judgment, is not required, otherwise that judgment becomes meaningless. Accused comes, giving notice, the evidence and affidavit is the evidence giving those documents, fix a date for defense evidence if you want, or if you want to cross-examine. If you don't want to cross-examine someone, you can do away with it also. Only that way you can finish it in 3 months. Sixth time, you can finish it in 3 months that way. But the lawyers will be furious, it's up to you. यसो गऱ्यो भने 1 हप्तामा सकिन्छ ग्याङमा त सकिन्छ see Rohini, this ponder upon it, you still be CJM for quite a number of years to come. Okay, if you can bring these changes, well and good, and fix the case for defense evidence unless an application is made by the accused under section 145(2) of the Act for recalling a witness for cross-examination. Now see, these judgments are the law of the land. What prohibits us from following it? We are afraid because we have never done that. We are still in that.
Does that mean that the accused will not be given the opportunity to cross-examine?
No, I understood what you are trying to tell. But can we go outside the judgment and say ourselves, we are not empowered to do that. Once the judgment is saying, accused can cross-examine. He has to say, I want to cross-examine these witnesses. Does the accused need to cross-examine a bank manager? I wonder whether bank manager is ever required. If the original check dishonor memo is before you, and there is a provision, what is that? Check dishonor memo need not be proved by the person bank managers. There is a section, I will look into it, somewhere around. It talks something of, it presumes the check dishonor memo as to, I forgot, it was a long time back. That's me on that.
146.
Yes, read it loudly, switch it on.
Section 146, bank slip prima facie, evidence of certain facts, the court shall, in respect of every proceeding under this chapter, on production of bank slip or memo having thereon the official mark denoting that the check has been dishonored, presume the fact of dishonor of such check unless and until such fact is disproved.
That's what, when the document is there, if someone has not come, you'll have to presume, right? Even if it is, but one thing that comes is, one may argue that the contents of the document has to be proved, right? But, the provision is saying, you can do it, it may be set aside, that's a different matter. But for you, तपाईँले त माइन त्यति मात्रै apply गर्नु पर्यो जति जरुरत छ. Why will you sit as appellate court and decide in certain matter? Of course, you have to think while writing judgment in the long term. You should not leave loopholes. But it says you can do it, positively let them challenge it.
It's a specific provision, so I think it might be.
The only difficulty, the problem is if I have 20 enact cases, by the time the appeal is decided in the appellate court, I may have decided 30 more enact cases on the same lines. And if it is set aside, those all 30 I will have to do something again, right? That prohibited me from becoming extremely legal law-centric. Otherwise, if you have 1 or 2 cases, if it comes back to you, you still have, you can still manage it. But in Gangtok, in 1 year, maybe you decide 30 enact cases on the same reasoning, and if that reasoning is set aside, then all those 30 will be re-registered before you, and so be sure before doing something. But yes, law permits, it's up to you. Because once the law raises a presumption, I think the Evidence Act's content thing must go away. That must give way to the CRPC provision. Accused to disclose specific defense if contest the case, which I already told. Trial shall normally be summary. Procedure for trial of cases under Chapter 17 of the Act has normally to be summary. Direction of the magistrate under the second proviso to Section 143 of the Act to hold that it was undesirable to try the case summarily as a sentence of more than 1 year may have to be passed is to be exercised after considering the fact that apart from the sentence of imprisonment, court has jurisdiction under Section 3753. So what does this mean is, if you are finding it that in this case you will have to pass a sentence which is more than 1 year, which you cannot do in summary cases, right? That should not be a sole consideration to say I will conduct it as a summons trial, because fine is the major penalty that we usually provide. And the provision says there is no bar in inflicting punishment of fine of more than 5,000 in summary trial. It says in Act itself. So that bar is removed. Direction to convert to summons trial to be exercised with due care and caution, and mechanical conversion shall be avoided. It speaks for itself. Court has no power to discharge the accused under section 258 of the CRPC. Affidavits in lieu of chief examination. Court has option of accepting affidavits of witnesses instead of examining them in the court. Witnesses to the complaint and the accused must be available for cross-examination. Here also it does not mandate it, but the thing is, why to go with all the cases routinely? Some of the NIAC cases are so simple. The lawyers will insist for you to go routinely. Okay? So, see the cases for yourself. Point it out. One case I had done, actually they did not go to complaint. I think it was a lawyer who is reasonable. I think one case we have done in but I was a little bit scared also. What if all my now if I do it in one, I have to do in rest of the cases, right? Accused not to be permitted to file chief examination in the form of affidavit, which when he said that accused shall not be permitted to file his chief examination evidence in the form of affidavit. He has to come to the dock and speak with his mouth. Appellate court to make effort to settle dispute through mediation. And there is one more. Compounding matter, there is judgment. At what stage you should compound and what is the ratio, percentage? What's that? Yes, yes. So when you are compounding, you must be very careful that beyond certain stage, the accused will have to pay certain percentage of the amount. As well, I don't know what compensation or fine, whatever it is. Yes, it increases, the slab increases. The more higher court you go, the more slab increases, right? So just compounding does not, when you see the judgment, it says that Damodar sure, Damodar is Prabhu's judgment. Plea bargaining to be considered. The absence of consent, compounding may be permitted. Quite important. Though compounding requires consent of both parties, even in the absence of such consent, court in the interest. What is the effect of compounding when it comes to accused? Quite so important, yes. That's why. Compounding leads to acquittal of the accused. We have to write accused is acquitted. And that means you are clean now. Okay. So that is why consent is required. Mainly of the complaint. But if, like I have given the bank details, the accused has paid the amount, a complainant got the amount, he is no more interested in case, he doesn't come to the court. No accused files for compounding. Would you allow or not? You have been told by the lawyer or anyone, or accused as a complainant has written something, you may not have, even in writing also, that he has got the money. There is no bar in compounding. He has got the money, finished.
It doesn't appear, then we can dismiss the complaint itself.
So at first date to dismiss it maybe, and given the facts that he has got the money. Right? Does dismissal lead to acquittal? One more conclusion of case, a mode of conclusion of case leads to acquittal. I am not remembering. Withdrawal. I think withdrawal leads to acquittal.
Withdrawal may lead to acquittal or discharge depending upon whether the charge is withdrawn.
So under section 258, sir, it amounts to acquittal.
The 258 is not like 51.
No. Withdrawal, see the withdrawal provision. Withdrawal of complaint. It leads to acquittal no matter what stage. It was earlier?
On the same
320 bracket 8, I think.
8.
Because
8 or 9.
these are very small things which you all ignore, but very important. Most of you all may not write, accused is acquitted. That's very important for accused.
359 for new ones.
Withdrawal.
359 is
For
compounding offense.
I know, withdrawal. No?
Withdrawal 360.
3 months, acquittal bacha.
Acquit.
Acquit, no? So no matter,
I think compounding, I was talking about compounding. It is compounded before. There is specific provisions.
Sorry, it's in 280 of BNSS.
What it says?
Sorry, it says that it will lead to acquittal.
No, I have not seen it. I'm confused.
Withdrawal of complaint, 280, yes.
So no matter what these states become to conclude it within 6 months, day-to-day basis is quite difficult. हाम्रोमा त possible छ, but no one comes. The lawyers do play कुदेट भनेर and we allow it. हैन? Others doing day-to-day basis case and they'll get mad at it. Lawyers will get mad. And we have to balance that factor also. Thankfully, there are no protests. I think Mr. Japan and any of Rohini ma'am would know that in the other jurisdictions, even if you refuse bail, your court is boycotted, right? And there is not only boycott, there is nara right in front of the court saying, if you refuse bail legally, usually I think it happens with very new magistrate once you are settled and in that particular place, because in their jurisdiction, how long do you stay in one place? Sometimes not even 6 months. I know my friend, he has been transferred for more than 14 to 15 times so far. And all the length and breadth of the state.
It depends upon the place of it.
Yes. So, different jurisdictions have their different problems, right? So day to day, even the law says that difficult is practical. But law will keep this provision forever, so that one fine day that situation might come when we are really civilized as a, as an institution which completes case in standard time. Otherwise, if you look at from the other perspective, aren't we uncivilized when we take years to decide cases? Right? Just take an example. All of us have been into hospitals. All of us have been in that waiting seats when someone else is ill. How bored it feels, and when they say that doctor comes at 9 o'clock, he doesn't come till 11:30, 12, and we are furious, accusing them. We are courts people are not saying much.
So if it depends
But they do say
on the judicial officer, then we would expedite it and finish it.
And you just have to see the witnesses, especially in Gangtok, in front of a courtroom, waiting till morning. Now there's a lunch break, you have to eat lunch. What to do? You see people, they're still outside, right? And some don't get vehicles to go back home. And what is that money which they get from court? So small. That file is there in High Court and it has to be enhanced by government. These things, I think, it's not that courts have to remind the government. It's their domain, they should be proactive. Right? Everything the courts have to remind to the executive that do this, do that, even though it's their domain to initiate themselves. So this all briefly I have for matters. Anything we can discuss.